Has the state prosecutor left?
I think so.
She needs to get back in here because I'm going back on the record on Mr. Lee at 1 o'clock.
Yeah, she has.
I want her here because I need a message gotten to that office right away.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Today's video is going to be a little bit different than what we normally do in an attempt to sort of branch out a little bit and try to give my audience or my viewership sort of a different viewpoint of various aspects of the criminal justice system that we haven't previously looked at on this channel. Today's video is going to come to us from a YouTube user called Old Squishy Gardener's Court Watch. This is a channel that I guess compiles different Zoom hearings or different courtroom hearings and comments on them or puts them on the internet for people to comment on. This particular video has gotten close to 700,000 views just based on YouTube's own reporting, which is a little bit behind. So it's probably over, maybe approaching 750,000 views at this point. But it's about a judge that I am particularly fond of because I think he's very fair and he does a great job in Michigan, named Cedric Simpson. I'm sure you've probably seen him because he's rather viral as it relates to TikTok and social media content. I believe he's an excellent judge, but I think he made a mistake in this particular case, and we're going to go through it and kind of talk about some of the behind the scenes inside baseball stuff that nobody really shares or talks about in the legal space. So with that, let's watch a few minutes of this hearing about a criminal charge and a misrepresentation that the state makes to Judge Simpson in the court and what he ultimately does. Let's take a look.
Court calls case People versus Don Lee.
Conrad Solar on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right. Please state your name for the record, sir.
Don Lee.
All right. Hey, where are we on this case?
Thank you, Your Honor. This is a driver's license case and I have discussed this with Mr. Lee. He will be accepting the offer extended to plead to MCL 257.326.
So, Your Honor, I'd move to add count 2 of MCL 257.326, allowing an ineligible person to drive. You accept that guilty plea to add count 2. I move to dismiss count 1.
Let's have Mr. Lee's one.
Raise your hand. Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Don Lee.
This court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. You understand that, sir?
Yes, sir.
And understanding all that, still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand by pleading guilty, you'll not have a trial of any kind, but
Yes.
you cited an advice of rights form, correct?
Yes.
Any question regarding those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's stated here today on the record to get you
No.
to plea? Anybody threaten you or coerce you?
No.
Doing this voluntarily
Yes.
of your own free will because you believe that you are indeed guilty?
Yes.
On the date of February 10th, 2024, Michigan Road near Moon Road, Pittsfield Township, Washington County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who is otherwise ineligible to operate that motor vehicle?
Yes.
Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court
Sir.
will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Anything you want to say before I impose sentence?
Just very briefly, Your Honor, Mr. Lee is asking that the court consider sentencing him to time served. I do acknowledge he wasn't arraigned on this case until September 19th and only has 9 days credit, albeit he was not being held on this case. Outside of that, I just leave it in the court's discretion.
Anything you want to say, Mr. Lee?
And I just wanted to get this over with and keep him going.
You come back on that other thing tomorrow. Is it tomorrow?
On the 8th.
For exam, Your Honor.
Okay, so this is what would be referred to in probably most jurisdictions as an open plea. Most of the time, when you plead guilty to something, you kind of already have, in exchange for the plea, you already have the sentencing worked out. But it looks like, and I don't know whether this is common practice in Michigan or whether this is just this particular case, but it looks like Mr. Lee has decided to plead open and just straight up plead guilty to count 2 of these charges and then accept whatever sentence the judge levies on him. Now, that can be risky, but some places don't give you the option. Even in Tennessee, there are some counties, some jurisdictions where the judges just simply won't accept prearranged sentences. Judge Simpson is pretty thorough here in going through. Apparently, it's common practice in Michigan to get approval from each party as far as whether the court is in compliance with the rules of pleas. So that looks like it's pretty thorough. And then you can tell sort of by the way that Judge Simpson is interacting with the defendant that they're familiar with one another. And so he makes mention of the fact that Mr. Lee is going to be before him on another matter. And then you heard the defense counsel for Mr. Lee state that he was not being held on that charge. So a lot of times what will happen is you'll be in jail on something else. And it's pretty clear from this video that Mr. Lee has some sort of a history with the court. And so he's probably being held on some other charge. And so he's sort of taking care of this. And a lot of times what will happen is you'll plead guilty to, say, this driving charge, and it will run either consecutively or concurrently to something else that you're doing. So let's say that you're in there on a more serious charge that's going to yield you some jail time. So what'll happen is you'll plead guilty to the more serious charge and you're going to serve, let's say, 90 days or 6 months in the jail as a way to take care of this charge. And so this person might come before the court and they want to wrap up this lesser charge and run it concurrently with the charge that they're already serving on. So maybe they're being held, they're going to serve 6 months on this other thing, and this is up to 90 days. And so if the judge sentences them to the full 90 days, it will be wrapped up if it's concurrent with the thing that they're already serving 6 months on. And so if it was consecutive, they'd have to finish that 6 months that they're already serving and then tack on the additional sentencing time from the judge. But it looks like Judge Simpson is getting ready to impose some sort of a sentence on him based solely on his agreement that he is guilty to the charges. Let's watch some more.
Just trying to recall, when I put you into custody, did we set an exam? Is that what we
Yes,
did?
exam is on the 8th.
Before me?
No, it's before Judge Burke.
Okay. All right. I'll take a look at that because all right.
I think I have the file up, Aaron. Did the court have a question I could help with?
Well, I put him into custody, but I know I told him I was going to take a look at that on the remand into custody on it because it came as a result of a police report regarding something else happening.
Yes, it was because there is a new case that is coming down the pipe, to which Ms. Blanche said that the warrant was going to be authorized that day, I believe. Mr. Lee advises, and I don't see anything to contradict that, he hasn't been arraigned on that new charge yet, however, but the 2 ones that he was in front of your honor for last week for PCC are set for exam, both cases in front of Judge Burke on October 8th. He's represented by Sam Bernstein in one and the public defenders in the other.
Okay. So my question becomes all right. That's right. That refreshes my memory. Where's that other case? Because the thing, I'm not asking.
Okay.
You don't know.
I know I ain't been arraigned on it.
No, I know, but I'm trying because I don't know. Did I change his bond on? I did change his bond on that. He was supposed to then be arraigned on the other case, but that case was supposed to there was supposed to be a timing on that case to get down. So I remanded him. He was going to be held on these cases, on the ones that are set for exam. And then that other case was going to come down, expected that he might be in on that case. But if that case hasn't come down, I'm not going to be very happy right now.
Yes, to my understanding, Your Honor, he has not been arraigned on that new case, but the 2 cases that are already set for exam in front of Judge Burke, currently his bond is $15,000 on each of those cases.
Correct. I get that. What?
You raised it was a PI bond and you raised it up.
I put it up because of the representation of these other cases but those other cases were what's the status of that other case?
Your Honor, Ashley Lottie, for the people on behalf of talk about these other matters. So if I'm reading this correctly, other cases was a resisting and obstructing case that was supposed to be coming down. Is that, Ms. Page, is that correct?
I don't think that was, it was involving a car accident and some other stuff.
I don't know the exact charges that were to be authorized, but I know the incident date was before the ones that are currently set for exam.
Right.
That being said,
I know.
Yeah.
Listen, where is that case? Because my problem here is that, and Mr. Lee is certainly not always the most cooperative person in the world, and he knows that. But he got remanded because his other case was coming down.
Correct.
And so I'm trying to, and I think there was a representation that it had been signed off or it was someplace. And the expectation was that case was going to get sworn out while in custody, he'd be arraigned. And then there would be, based upon the facts of that case, a bond set that was likely or may have, I won't say, I can't say for sure, may have kept him in custody, which is why I did what I did.
That was my understanding, Your Honor.
I just need a little bit more information.
Go, look.
So I want to understand, Mr. Lee was last before the court for PCCs. The court is saying on the 26th or the 18th.
I think it was a week ago, wasn't it? I think it was.
The 20.
I think it was the 26th. He was before me.
I have some help helping right now. So the new case, which does appear to be related to fleeing and eluding charges, dated date of incident 8/29/9/20 to 9/2. It appears that case was authorized, signed by my office on 9/26, and I don't see.
That's what was indicated to the court on the record, that it was signed off on 9/26. But then there was a representation that it was going to get sworn to. It was signed off by your office. I think that's what was represented to me. It was going to get sworn to so that Mr. Lee could be arraigned on it.
My understanding is that Magistrate Fink signed that case on September 30th. It is likely,
well, then why hasn't he been arraigned?
I'm not sure, Your Honor. It may be in a stack of things that are waiting to be entered. That's been happening.
Oh,
I don't.
no, that will not happen. Miss.
Can you tell me what the jurisdiction is? Yes. It's not.
It's
not
Ypsilanti City. It's Ypsilanti City.
It's a city case?
No, I showed us
It's a
14B.
sheriff's office. It's a sheriff's office arrest that occurred in Ypsilanti City.
I show with the 14B.
Okay, so it's on the line. It said the swear out was on the 30th.
I have a police officer.
Oh, really?
Yes, that helps.
So, whoa. Is that what the log notes indicate?
Yes,
So there are no charges?
correct. It says court does not find probable cause.
Okay. Just hold.
Okay, so the swamp of the criminal justice system is starting to rear its ugly head here in this particular situation. And this is the problem. This is the problem with collegial relationships within the local bar. And look, my local bar is very, very friendly with each other, very collegial. But when you have those types of relationships, advocacy dies. In that everybody just trusts that the other person is going to do the right thing. And what happens is you become less of a zealous advocate for your client because you're just assuming everybody's operating on good faith. So if you paid attention to what was said there, the prosecutor made an assertion to the court that there was a new case coming down on Mr. Lee. And the prosecutor told the court that that warrant would be authorized on a particular date. Well, here's the problem. Warrants, as you know, because you're probably a constitutionalist if you watch my channel, or at least you're interested in it, warrants have to be approved and signed by a neutral and detached magistrate. And that is either a true magistrate or a judge or whatever the format is in whatever state you're in. But a prosecutor can never be sure that a warrant is going to be authorized because the prosecutor doesn't know what's being put in the facts or the complaint part of the warrant. And if the magistrate is truly neutral and detached, how would a prosecutor know whether the magistrate's going to find probable cause in that situation? The answer is they can't know. And so what's happened here is the judge has taken an action against this defendant and has remanded him into custody based on the word of the prosecutor that a warrant is going to be come down for a second offense. The warrant never came down. And the judge is going to be mad. But the problem is that the judge should not have relied on what the prosecutor said insofar as using it as the basis to take an adverse action against the defendant for a charge that may come in the future. And again, nothing but respect for Judge Simpson because I think he does a great job and he's conscientious and I like the way he handled this. But he really exposed himself here to a judicial ethics complaint because on the record, the basis for remanding him into custody was that this new charge was coming down. But the judge should not be considering charges that may come in the future, especially where the person offering that information to the court is not the decision maker as to a finding of probable cause. And so he's really damaged the defendant here based on the word and the sort of good faith assumption or the benefit of the doubt assumption by a state prosecutor, and he's not happy about it. This is not good. This is not something that should be happening from an independent and impartial jurist. Let's continue.
That's what it says?
Yes.
So there is no case.
Can I confirm the police report number for that? Yeah, I have it on. Washtenaw County Sheriff's Department report number 24-67821. I have 68821. I don't know if that's a typo, but
And
I'm checking with Melanie.
yes, and while you're checking with them, have me bring them Mr. Lee's other two cases that are set for the 8th immediately. Mr. Lee, that's what we're gonna do. I'm gonna have them take you back.
Okay.
Court recalls case people versus Don Lee.
Sir, is the court calling the felony matters or the
I am calling the felony matters also.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right, please state your name again for the record, sir.
Don Lee.
And I'm calling so that we're clear, 24 FB 1322, as well as 224 F 1261.
It was 1322 and 24F2 1261.
The felony matters, yes, ma'am.
Thank you, Your Honor. Actually, I for the people in both of those matters.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right.
I still have to sentence him on the driving well or the operating well. So we've taken a look at it. That complaint that I put Mr. in custody on there was no probable cause found. And so that was not done. And I'm going to say this. They knew the reason. Mr. Lee understood what I was doing and putting me in custody. The prosecutor's office, I think, was given the representation made to this court, was under an obligation to contact this court immediately upon notification that those charges were not brought, knowing that affected Mr. Lee's liberty. And I'm not happy that I wasn't contacted at all. Anything you want to say before I sentence him on his misdemeanor?
Nothing further, Your Honor. I would just reiterate his request be sentenced to time served on that misdemeanor.
Fines and costs of $250. Those fines and costs are waived in their entirety. 90 days suspended on that case. With reference to his felony matters, those will continue to preliminary examination on October 8th before Judge Burke. Bond on those cases, both will be set at personal recovery. The conditions will remain. They never left. It's just they took his liberty on something that didn't get authorized. You're going to be free to go.
I'm going home today.
You're going to be let out, sir.
Thank you.
Thank you very much, Your Honor.
Court's going to stand in recess.
All right. Thank you, Your Honor.
So this is something that is another issue when it comes to representing defendants. You've got this lady working for the public defender's office. He is apparently being represented by some other attorney that probably stands in conflict. And then he's being represented by another member of the public defender's office for a different case. Here's how you end up with a hodgepodge of lawyers representing people on cases. So, in Tennessee, for instance, if you get arrested and you don't have the money to pay for an attorney, you are represented by the public defender's office. And generally the law says that the public defender's office represents people who are indigent unless there's a conflict. And so the public defender goes through their conflicts checks and they make sure that none of the parties involved in this case, be it a victim, a witness, or the defendant themselves, are standing in conflict with somebody else that the public defender's office already represents. So you might have a case from 6 months ago that the public defender's office represents Mr. Lee on, but this new case may have a co-defendant involved that the public defender's office already represents in something else, and so they can't represent Mr. Lee on it. And so what happens is that case, the new case, gets assigned to a private attorney that is willing to accept like court appointments. And sometimes I do some of that work, and I'll accept court-appointed work for people who can't afford to hire a lawyer because the public defender has a conflict. And I do that as mostly like a favor to the courts, because sometimes you'll get 4 or 5 people arrested involved in some sort of conspiracy or something like that, and the court just simply doesn't have enough attorneys to represent them. And so you've got these people that are sitting in jail and they don't have attorneys. And so sometimes I'll take on those cases just as a matter of trying to get people out of jail or make sure that they're not just sitting there simply because we don't have attorneys to help them. But one of the problems that is akin to that idea is that you have a bunch of different people who don't know what's going on. This lawyer could be making an argument as to why her client should not still be incarcerated with a higher bond based on some presumptive charge that was going to come down, and how that's unfair. And she could be making an argument for her client, but there's so many people involved, she doesn't even know the details as to what's going to happen or what was said. And so you plug different people in, and you'll notice that when we get to the end of this video, the person that's going to stand here and take the heat from the state's prosecutor's office, from the judge, is not even the person that was there an hour before the court recessed for lunch. And so you got all these people that are sort of plug and play, and that's what you have when you have a public defender's office and a prosecutor's office, is whoever's there is the person who's representing the people, or whoever's there is the person who's representing the public defender's office. So this defendant might have one attorney today, but a completely different attorney in a week, because they all work for the public defender's office. And it becomes very confusing. And when you have the assumption and the benefit of the doubt being tendered to everybody as if there's a good faith basis, advocacy dies, because this guy's been sitting in jail for 9 days on a charge that we're going to find out is not coming. And so the judge is mad, but he's really mad at himself because he knows that he shouldn't have done that. And that's written into the judicial canon. So let's take a look at the judicial canons that might be in play here for the state of Michigan. Canon number 1 for the Michigan Code of Judicial Conduct: a judge should uphold the integrity and independence of the judiciary. An independent and honorable judiciary is indispensable to justice in our society. A judge should participate in establishing, maintaining, and enforcing, and should personally observe high standards of conduct so that the integrity and independence of the judiciary may be preserved. A judge should always be aware that the judicial system is for the benefit of the litigant and the public, not the judiciary. And why that matters is because if the judge is doing what the prosecutor's office asked, based on information coming one way from the prosecutor that is not verified, that is not an independent judiciary. That is the prosecutor leveraging the trust of the court to get a benefit and hold this guy into custody longer, and it's based on something that will ultimately not materialize. And so in this case, it brings into question the independence of the judiciary, because instead of acting independently, neutral, and detached as a judge, the judge has acted on a statement by the prosecutor with no evidence. And that leads us to canon number 2. A judge should avoid impropriety and the appearance of impropriety in all activities. Public confidence in the judiciary is eroded by irresponsible or improper conduct by judges. A judge must avoid all impropriety and appearance of impropriety. A judge must expect to be the subject of constant public scrutiny. A judge should respect and observe the law. At all times, the conduct and manner of a judge should promote public confidence in the integrity and impartiality of the judiciary. Again, impartiality, independence, neutral and detached. These are things that should not even, the appearance of which should not be in question. And again, I think Judge Simpson does an excellent job in what I've seen him do over the course of the time that I've seen him on social media. But he really exposed himself, and if he didn't directly violate the canons, he at least called into question whether or not the judiciary in this particular case has been neutral and detached and impartial and independent, because he's made an adverse finding against the defendant based on a statement by the prosecutor that actually did not materialize into any actual charges. So let's watch and see how this ends, and then we'll come up and wrap it up with closing arguments.
The 14th District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge J. Cedric Simpson preside.
Has the state prosecutor left?
I think so.
She needs to get back in here, because I'm going back on the record on Mr. Lee. I don't know who else has that case. You may be seated, folks. Yes. At 1 o'clock?
Yeah, she has.
I want her here. I need a message got to that office right away. Court is recalling the cases of the people versus Don Lee, both his felonies and his misdemeanor cases.
Good morning again, Your Honor. Shady for the people.
Assistant Public Defender Natalie Pay on behalf of Mr. Lee.
I'm going to waive Mr. Lee's appearance because they took him down so he could be processed out immediately. But I want to make a record clear and know, and I realize, Ms. Lundy, you were not the one involved, but I am more than livid right now, because this case, we went back and checked our records. Mr. Lee was taken into custody on the people's representation regarding the previous case. I took him into custody at 11:43 a.m. on June 26th. After having him wait here in court, I took him into custody on that date, and it's important, at 11:43 a.m. on the 26th. There was an attempt to swear out that case that was done before Magistrate Fink less than an hour later at 12:31 p.m., where the magistrate did not find probable cause. And this court was not informed. Mr. Lee was in custody. It was another attempt made to swear out that complaint on the 30th. Again, no probable cause. It is inexcusable that the prosecutor on their representations had this court act that deprived Mr. Lee of his liberty for 7 days. Inexcusable. So, Ms. Lundy, again, while you are not the person that was involved in this, but has done, I will expect a call from Ms. Burton Harris regarding this matter.
Yes, Your Honor.
Today.
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
Okay, so now we find out that on 2 separate occasions, the prosecutor's office had taken a representation or their witness to the magistrate to swear out these warrants, and they were declined for lacking probable cause on 2 separate occasions, and no one notified the judge. Now, we went through the judicial canons again, and we understand that the judge has made his decision based on a statement by the prosecutor. But in that particular case, he could have just reached out and asked his clerk, hey, can you grab the copy of the warrant from that magistrate, and let's make sure that this is actually in play before we do something good or bad. I guarantee you, moving forward, he'll never do this again. He's learned from this. You can tell he's very upset about it. But again, he really should be mad at himself because, again, neutral, detached, impartial, independent. The prosecutor, even though their tactics may be shady, their job is to advocate for what they see as justice or the interests of the people or whatever. And the defense attorney, it's an adversarial system. Your job is to advocate for the interests of your client. The court's job is to try to whittle down all of that to what's factual. So the judge is supposed to be looking at what can be taken as credible testimony from the witnesses, i.e. probably the police officer or whoever is involved here, and try to determine. And the magistrate in the case that they thought was coming down looked at the facts that were alleged by the person who brought forth the warrant and said, no, I don't believe this happened. Or it said, I don't think that the facts as you've alleged them rise to the level of meeting the elements of a crime. And so the magistrate probably did a good job of being neutral and detached, because on two separate occasions where you've got one person that's already incarcerated for other stuff, and it would just be easy to rubber stamp that, the other magistrate has looked at this warrant affidavit and said, hey, no, I don't see it. I don't see it, either because I don't find the witness testimony credible or because I don't think that the facts as alleged rise to the level of a crime. And so the judge should have just to cover his own butt, because he's the one who would ultimately be held accountable for making an adverse decision against this guy based on a statement alone. He should have done some fact checking to make sure that this thing actually happened. What he's really upset about is the fact that they leveraged the relationship. He allowed them to do it, and then they didn't notify him that the case was never signed off on by the magistrate and there was a no probable cause finding. And you know they knew about it because they tried twice to get it done and failed. In closing, this really is part of what's wrong with the criminal justice system. You have all these government bureaucrats. They work 9 to 5 Monday through Friday. They're off on the holidays. All they care about is their cushy job. And I'm not talking about Judge Simpson. I think he genuinely cares about his job. But, I mean, judges in Tennessee make between $175,000 and $210,000 a year, okay? And they get state-sponsored health insurance. They get retirements. They get special pensions. And the problem that you have is that none of them are held accountable unless you do something horrendously egregious in the capacity as a prosecutor. Like, you get full immunity for prosecutorial decisions. So this prosecutor could just make the assertion that all she told the judge was that the case would be signed off on, and her intention was that the court would understand that that meant her office had signed off on it, not that the magistrate had signed off on it. Ultimately, it fell on the judge's shoulder to make sure that this document was in front of it before it made the decision. And nobody gets held accountable. And this guy's sat in jail for 9 days. He's got an extensive criminal history, so nobody's going to feel bad for him. And nobody's going to think, well, 9 days of this guy, he was going to be in jail in another county on something else. But every single person should be treated constitutionally when they come into our system. And it's easy to see as an outsider looking in how you could look at it and think, we just need to burn the whole fucking thing down. It's completely corrupt. And the truth is, it's more about incompetence or no direct accountability than it is intentional corruption. But it's hard to make a defensive argument about why it's not corrupt. And so if from the outside looking in, it looks corrupt, and you can't come up with a reasonable thing to say in defense of it that would make it obvious that it's not corrupt, it's a distinction without a difference. And basically what you have to ultimately acknowledge is that the whole thing is corrupt and it needs to be burnt down and to be redone from top to bottom. And that includes lawyers, judges, cops, district attorneys, everything. We need to wipe it and start over. And it'll never happen because it's too hard to do that. For one, it's 100 years behind everything else. And the people who make the decisions, all these judges, they're in their 60s, 70s, 80s. They're not in touch with the 2024 stuff, right? A lot of these guys don't even use computers. And I'm not exaggerating. And I don't know what the answer is that's feasible anyway from a government perspective, because the truth is it just needs to be wiped and start over. But I know that you guys don't get a lot of this about how this stuff actually works and what's actually going on here. But a lot of relationships get leveraged in the criminal justice system. And I can see where you would look at that from the outside and be like, yeah, everybody's in everybody else's pocket. Well, he's friends. He don't want to make the judge mad. They're golfing buddies. I have personal relationships with multiple judges in my county. We do different things together. Some of us are training partners in working out or jiu-jitsu. Some of us play golf together. Some of us do different things. Our wives are friends. We go out to dinner. Those types of things. I would never try to use that. And I mean this. I'm not saying it for the purposes of a video. I would literally die before I would use my friendship with somebody to leverage it to get them to do something improper. But not everybody's like that. And not every courtroom's like that. And every single place where you have a different judge and a different set of rules is all like its own little universe where everything works a little bit differently. And so anyway, I just thought I would give you guys some behind the scenes stuff, see whether or not you have a different opinion about it than me. What do you think about the system? Do you think this is just diseased and broken? Do you think this is an honest mistake? Do you like Judge Simpson? Do you not? Where do you stand with him? Anyway, that's all for this one, guys. Thanks for taking time to watch it. Please remember to like and subscribe. And like I said, leave a comment. Let me know what you think about what's going on here. Check out some of the other videos on the channel. Leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.